Hello, everyone. Thank you for joining us today. I'm Marche, the webinar director at Advice Chaser. Before we introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you today's educational presentation. And we will encourage you, even though you are muted, to go ahead and use the chat box to ask questions. The presenter will answer those queries during or after the webinar today as appropriate. And I will ask one thing, that if you ask a question in the chat box and we don't have a chance to get to it, go ahead and leave your phone number as well. We will make sure someone reaches out to you after today's event if we are not able to get to your question during the presentation. We want this experience to be as educational as possible. Please don't hesitate to ask for clarification or expansion of the material. That's what we're here for. Well, I'd love to introduce you to today's guests. Our moderator today is Chase Tushouse, and he's a partner with Tushouse Wealth Management. Prior to becoming a financial advisor, Chase worked in the manufacturing industry as an engineer for L3 Harris and SpaceX. Chase graduated from the University of San Diego with a Bachelor of Arts and Science degrees in Industrial and Systems Engineering. He's a member of the University of San Diego Alumni Board, the co-chair of USD Shiley Marcos School of Engineering and Computer Science Alumni Council, and a member of the Oceanside Theater Company Board of Directors. He and his wife, Julia, spend their time mentoring local youth. And Chase, why don't you come off of mute and say hello so we can see your face?
Hey, thanks, Marche. Appreciate it. Excited to be here and moderate Erin's, Erin's presentation today. I think it's gonna be fantastic. I've worked with her in the past, and I know she's very knowledgeable in her field. So I'll let you introduce her now, Marche.
Great. Well, we'd love to introduce our speaker, and forgive me if I pronounce this wrong, Erin. I didn't ask the pronunciation of your last name. Is it Erin Funderburk?
That is correct.
Okay, perfect. Erin Funderburk's practice concentrates on estate planning, trust administration, and business law. She graduated from the University of Georgia with a BS in Business Administration, and then received a law degree from the University of North Carolina at Chapel Hill. Following a decade working at large law firms and in-house for a company, Erin sought a new environment that fostered a personal, collaborative, and client-centric approach to legal services. Erin realizes that each individual and business is unique, and the one-size-fits-all approach adhered to by many law firms is flawed. She works closely with her clients to understand their unique obstacles, hopes, fears, and overall goals. And we're excited to have you present today on beneficiary designations. So I'm going to go ahead and turn the time over to you, Erin, and we'll get started.
Perfect. Thank you for the introduction, and Chase, thank you for allowing me to present today. As mentioned, I'm an estate planning attorney in San Diego, California. So this presentation will focus a lot on California law, but most of the concepts that we discuss today exist in other states as well. Want to give a quick disclaimer that the information and opinions contained in this are for general interest and informational purposes only. It should not be relied on or treated as a substitute for specific legal advice. If you need specific legal advice relating to estate planning or business law, you may contact me directly. So again, this is just general advice, and no attorney-client relationship has been created by this presentation. So as an estate planning attorney in California, I frequently advise clients on how to stay out of probate and mistakes that they could make that could result in probate. This is a term that I may use throughout this presentation, so I want to quickly address what it means. So the probate process, and this applies in every state, but in California, if a person passes away and they have no documentation at all for estate planning purposes, or they only have a will, then most likely they will end up in the probate process. And this is referring to a formal legal process by which a judge will oversee the collection and the distributions of all the property that the person owned that has passed away. It's incredibly disfavored in California for several reasons. On average, it takes about 18 months to get through the process. And attorneys' fees by statute range anywhere from 0.5% to 4%. So what that means is if you were, upon the time you passed away, had $1 million in assets, you're going to be paying an attorney $23,000 to handle this process for you. And as mentioned, it could take about, a year and a half to complete. So your loved ones have to continuously be involved in the process during all of that, as well as distributions generally are not made until the very end. So because of that, as part of the estate planning process, I usually inquire about what we refer to as non-probate property and probate property. And when we say non-probate, that's any property that passes upon the death of a person that is not subject to the administrative process. So common examples are retirement accounts, life insurance, trusts, joint tenancy accounts, and payable and death accounts. And most of these are assets or property that are transferred pursuant to what's called a beneficiary designation form, which is the topic today of our presentation. And this presentation is going to go through top 10 mistakes that I have seen and are very common in connection with these beneficiary designation forms. And not only are attorneys and estate planners, very familiar with these beneficiary designation forms, but also to financial planners like Chase. And so it's really important when you're working with a financial planner or when you're working with an estate planning attorney, you're double checking all these beneficiary designation forms and you're providing the necessary information to your financial planner and your attorney so they know what you have. An important thing to note, at least in California, is that any property that's transferred by one of these beneficiary designation forms cannot be transferred by a will or trust. So what that means is if in your will or your trust, you designate an individual to receive your life insurance proceeds, but on that beneficiary designation form, you name someone else, that form is going to trump whatever you state in your will and your trust. And it's really important to remember this because this could result in adverse tax consequences if the incorrect person's named, or the failure to leave your property to who you intended. Or even worse, perhaps you inadvertently leave out a family member from inheritance because you didn't realize this. So, and if you wouldn't mind moving me to the next slide. So the the first mistake that people make is not to name a beneficiary at all. And Chase would never do this, but other times I've seen this happen where someone's in such a hurry to sign up for a 401k or a brokerage account, whatever it may be, and there's a form for them to complete the beneficiary designation and they either don't have the time right then, or they say they'll get back to it, or they don't know what it means, so they don't complete and put anyone on the form itself. This can have very undesirable results because if you don't name a beneficiary, for instance, for a life insurance policy or a retirement account, then the financial company each one has its own rules about where the assets will go or the property will go once you pass. So really it at this point would default to what the company has determined and where it goes. And for retirement accounts, if you're married, at least in California, but most likely by default, provide them to your spouse. And if you're single, most likely would be distributed to your estate, which is another term that we refer to. But either one of these situations could have adverse tax results. It could require a 5-year payout. In general, this is just not the route you want to go. And even people that say, well, I've named beneficiaries, I checked it 5 years ago, I'm never going to change it, so why do I need to look at it again? There was a case in Florida with a man named Thomas, I'm going to mispronounce his last name, but Ozimkowski, that had completed his designation forms, done everything that he needed to do, and then throughout a shuffle and a transfer merging with Wachovia Securities and Wells Fargo took over the entity, certain forms were lost and couldn't be recovered, and one of those was his beneficiary designation form. And so the result of that was that it still ended up going to the proceeds, and his property ended up going to his wife, but the payout was different than otherwise would have been, because they had to name his estate as the recipient instead of her individually. So again, very important that when you open any of these accounts, you name a beneficiary, and then you check them on a regular basis to ensure that they're still named. I even have, my clients, I tell them print out copies and put it in your binder so that, there's confirmation to third parties if they need it, who you've named. And if you can move to the next slide.
Hey, Erin, actually, we just got one question in here, if you don't mind me
great.
interrupting for a sec.
That's
So
fine.
you're kind of talking about now, like actually naming a beneficiary on a beneficiary designation form. You talk about like having a relative or a spouse as a beneficiary. Can you also have like an institution or another entity, or even, I guess, a nonprofit?
Yes, so you can name individuals, and we'll get to one of the other mistakes in this presentation talks about being specific as to who you name, but you can name spouses, individuals, you can name friends. You can also name charitable organizations or foundations that are handling it for you. And as I'll indicate later on, if you're naming, for instance, a charitable organization, it's a good idea to ensure that you have the correct legal name, as well as most entities have an EIN, which is similar to a social security number. They could also be identified after their name by that EIN to ensure that the correct recipient is receiving those benefits. And again, this is under, specifically I'm licensed in California, but for a lot of charities, it's actually beneficial from a tax perspective if you're already planning on leaving money to charities, to name them directly on certain types of retirement accounts, because they get tax advantages from that. Thanks for the question.
Awesome, thank you. Yeah, thank you.
So another, don't want to say mistake, but mistake that I commonly see is that people only name a primary beneficiary. And so again, it's really important not only to name a primary beneficiary, which is the first person that you would want to receive that property if something were to happen to you, but also contingent beneficiaries as well. And so it's really important because sometimes, these documents aren't updated as frequently as they should be, and someone may name a spouse, or they may name, for instance, I have a client recently that named a sister, and then over time something happens and that person is deceased and no longer able to receive the money if something were to happen to you. And then the default again is it goes back to what the institution has determined is the default for their contracts or for their beneficiary designation forms. So again, really important that you update those forms, make sure that they have the individuals listed, revisit it every couple of years to ensure that circumstances haven't changed. If you can go to the next slide. So on that point, another mistake I see is your failure to keep the designated beneficiaries current. It is important to continuously review these and ensure, especially during any life-changing events, think marriage, divorce, new children, children were minors, now they're no longer minors. Continue to look at this because you may have listed an ex-spouse on your beneficiary designation form, or maybe someone that's now deceased, or an estranged family member that at that time you guys had a great relationship and you no longer do. I routinely find clients forget who they've designated, or they think they've designated one individual and it ends up being someone completely different. And in California, specifically, a divorce does not automatically remove your ex-spouse as a beneficiary. And there's actually a case with the Life Insurance Company of North America and Ortiz, where someone got remarried, failed to update their beneficiary designation form, and their ex-wife, because she failed to update this, their prior spouse or their ex received all of the property that was in that account. And because of this, his surviving spouse, so his new wife and his children that he intended to receive the proceeds from the life insurance policy, received nothing. So again, double check, especially if you have clients that are going through, or if you're going through any of those circumstances, ensure that you're going back and changing these forms, because if it lists an ex-spouse or someone that's deceased, that's who it's going to, regardless of what your other estate planning documents say. So again, review them regularly and certainly after any kind of life event. We can go to the next slide. So vague wording, and this relates to what Chase had asked earlier about, can you name whoever you want on these beneficiary designation forms? You can, but I urge all of you to include with as much specificity as you can as to who you intend it to go to. A lot of the times you have individuals in the same family with similar names. Maybe you have John Smith II, John Smith Jr. Maybe, there's a family name that you find repeated all throughout your family chart. It's really important to specify exactly who you're referring to so there is no confusion, or that other individual in the family can't claim that it was intended to go to them. So I generally recommend, using middle initials, using middle name, if they're a second or a third or a junior or a senior, to include that, as well as, however specific you want to be. If you want to say Jane Smith, spouse of so-and-so, and her birth date is this, or this is her social security number, be as specific as you can. Sometimes people will, and as I mentioned with charitable organizations or businesses, you can include their EIN, which is an identifiable number. And on that note, when I'm planning for individuals that want to identify charities, I will contact these organizations myself. A lot of times too, on their website under giving, they'll also identify their EIN for purposes such as this, but I will include it in all of their documentation up front so it's very clear who it's going to. Another component that I see sometimes is parents will say, primary beneficiary is my spouse, and the backup or the contingent is all my children. I would recommend you not state that if possible, because what happens if one of those children passes away? Does their share go to the other child, or does the share go to their children? Again, I would be as specific as possible in these documents. And sometimes some institutions will have limitations on how much you can input in the form, but I would try to include as much specificity as you can. And if we can go to the next slide. So another mistake that I have seen, and again, I think I've lost track of what number we're at here, but is naming a child as a beneficiary. So not every person can receive property directly, such as minors. So minor children aren't legally competent, so they can't claim the property. And in California, a court-appointed conservator will have to claim and manage the property for the child until they turn 18 years of age. We do also have some options under the California Uniform Transfers to Minors Act that will allow the money to be set aside in a custodial account that will then be distributed to that child when they turn 18 years old, or in California, if it specifically indicates, can be extended to 21 or 25 years of age. So number one, naming minor children directly, knowing that it's going to have to go through that judicial process, as well as to be set up in a custodial account when someone else overseeing it. So it's better to go ahead and make arrangements beforehand. Also too, this is a circumstance in California where a trust is really valuable. Not only trusts are great if they're properly funded to hopefully avoid probate, but you can also allow the trust to hold on to property longer, so a child doesn't receive a large cash sum at 18 years old. I know me personally, myself, if I was 18 and received my parents' entire retirement account at once, I'd have concerns about my maturity level and how I spent that. So by utilizing a trust, it allows parents, to determine different milestones for when their children are eligible to receive portions of the property, and it allows it to adhere to their goals and not necessarily be distributed all in one lump sum at 18, which is what would happen otherwise. So
Hey,
go ahead.
Aaron, sorry to interrupt. Yeah, we actually had a question come in kind of about naming children and spouses beneficiaries. I know you kind of mentioned before that, traditionally the state would see the spouse as like the primary beneficiary if it wasn't designated, right? But let's say, and I know sometimes to not select your spouse as a beneficiary may require additional steps. If someone were to specify, like, let's say 60% goes to spouse and 40% to a sibling or child, is that something they can do? And are there certain requirements for them to be able to do that?
Yes, so you are correct, and that's going to be one of our other slides is at least in California, because we are a community property state, it is assumed that 50% of most of your assets are community property and thus that of your spouse. So if you try to name as a primary on your life insurance policy, retirement accounts, someone other than your spouse, it is actually invalidated up to their portion. So if you're at an institution or you're completing beneficiary designation forms and you want to identify someone other than your spouse, they'll allow you to do that, but you generally have to have your spouse sign a waiver to any rights that they would have for that being marital property. But you do have that option. But also too, keeping in mind, if you name your spouse 60 and your children 40%, and something were to happen and be distributed to them, they're going to get their 40% as soon as they turn legal age to obtain it. So something to consider.
Gotcha. Thank you. And we did have like one spinoff actually from that question also come in. So if you were to name your spouse as the primary beneficiary, and then if you have minor children, would you then want to set up a trust, have them as beneficiaries in the trust, and the trust as the contingency beneficiary, or would you put the children?
So that kind of goes down a little bit of a rabbit hole of something that we can, if you want to reach out offline, it relates to something called the Secure Act, but there were changes recently that by naming trust because you have the option of both of those. You could name the children as secondary beneficiaries, knowing that they're going to receive it outright. You could also name a trust and in the trust specify when those individuals get and how. But because of recent changes, there's a difference in the distributions from retirement accounts that can have a pretty significant impact for tax purposes, depending on if you name a trust versus children individually.
Gotcha. Thank you, Aaron.
Yeah. I think, okay, and we have one more question, but maybe we'll get to that. Do you want me to go ahead and tackle it?
Why don't we go ahead?
Go ahead.
Okay. All right. So I'll go because at the end we'll have a brief question and answer section as well that I can address additional questions that come up. So again, in addition to children, some other people that you may want to reconsider if you're going to name them as a beneficiary. And the next is any individual with special needs. So not only is it important because they may not have, depending on why they're deemed to have special needs, they may not have the capacity or the deemed legal mental ability to financially handle their own affairs. But even worse, it potentially could disqualify them from various benefits and government assistance. So for instance, it could interfere with the medical eligibility for an elderly parent or a special needs kid from receiving SSI, because a lot of these government programs have income qualifications. And if that person receives a large sum of cash, it could disqualify them from receiving those. So another alternative that I see that's also not great is when people say, all right, well, then I'm not going to leave anything to the special needs child or to my parents because I know that the rest of the family will take care of them. Good intentions, but if you really want to ensure that that individual will be taken care of, at least in California, there's the option to create special needs trust, which allows money to be held in the trust, and it supplements on a very high level, it supplements any government benefits that the individual is receiving to ensure that they're not disqualified, but also to ensure that they're taken care of. And if we can go to the next slide. Another thing to consider when you're naming beneficiary designations, and sometimes a mistake that I will see is that the individual will name someone that either has significant medical issues, is at a higher risk of bankruptcy, or generally has creditor concerns. So for instance, if someone has significant medical issues, there's a high likelihood that they're also going to have significant medical debt. Or if someone's going through, potentially could go through bankruptcy or has a lot of money due to credit card companies, it may not be a good idea to name them directly as a beneficiary for certain types of property, because any amount will be distributed and made to them outright, and then it will be accessible to creditors immediately. So this is another situation where it may be a good idea to keep the money in a trust for these individuals and allow only disbursements on a needs-based circumstances or at certain ages or certain other notable events, because if someone does have creditor issues, debts, outstanding liens, and they receive a large sum of money, their creditors will now know that they have accessible cash to pay that. Same thing with medical issues. There's a lot of debt. So something to consider for individuals in your family that may fall within one of those categories. You might want to consider a trust instead to help secure the money and ensure that they receive what they need over a longer period of time and are taken care of. And the next is another mistake I see all the time is when individuals name another person as a joint owner on an account. So most of the time when I hear these circumstances, it's elderly client says, I just have such a hassle paying my bills. I can't use the computer. I can't see what's on these documents. I'm having issues driving. And my one child, my youngest, lives nearby. So I'm just going to add her as a joint owner on my account so she has full access and she can do everything that I need her to do. And a lot of the times, the individual may think that it's a power of attorney, which is the document that's you designate someone else as your agent to be able to manage certain financial accounts and affairs for you on your behalf. But by adding them as a joint owner on the account, it is though you have gifted them half of the value in that account. And as with beneficiary designation forms, any property that's held in joint tenancy cannot be transferred or altered in California, at least by a will or trust, if the documents conflict as to who's going to receive it. So the parent may think, I'm adding this child, they can pay my bills now, and then when I pass, they can also use that money to pay for my funeral bills, care, any other expenses I have, but with the general intent that, my youngest daughter, I trust her, and anything left over, she will, divide equally between her siblings, because that's what my trust says, and that's what she knows that I would want. Legally, that child does not have to do that, and very frequently, at that point, and I have heard comments from children of, I've had to go through so much. I was the one near mom. I was the one paying the bills. I was the one driving her around. And I'm entitled to this money because I was the one that was there when my other children weren't because they were further away. And legally, that child, because they are joint owner on that account, is entitled to all the money in that account and can take it all. And they don't have to share it with any of the other children. Another concern to think about sometimes if you add a child or another person as a joint owner on your account is because you've gifted them technically half of what's in that account. it is now theirs and it's reachable by any of their creditors. So again, if you name someone and they have issues with creditors or debt or bankruptcy, now they technically are legally entitled to the money that you have in your account, and their creditors can claim that they own half of that. So something to consider. I would highly recommend in those circumstances, instead of naming them as a joint owner, if your intent is for them just to help with paying of bills, complete a financial power of attorney. Each state has a different version. Some states will have an approved statutory form, like we have one in California that you can pull on the internet, as well as most institutions have their own form as well, that if you ask for their form of power of attorney, you can complete that as well and describe what circumstances you want that person to be able to access your money and your funds and what they can do. So if that's your intent, that's the route I would recommend you go instead. So the next slide, as Chase mentioned earlier, is forgetting about spousal rights. So each state's a little different. Like I mentioned, California is a community property state and your spouse has rights. And so in the general rule is that any non-probate transfer of your community property, such as a beneficiary designation form, on death by a married person, if they don't get written consent of the person's spouse, it is not effective. So this is insurance policies, promissory notes, pension plans, individual retirement accounts. So in those circumstances, the court will actually reverse and set aside whoever you designated and give that percentage to your spouse because they were the one that legally was entitled to it. As mentioned before, you can get your spouse to waive their right. A nuance, at least in California, and something to consider is if your spouse is willing, let's say you want to leave your life insurance to your one child instead, and your spouse says, I'm willing to waive my right so that you can name this child directly. They'll sign the form, waive their rights to it. Once that spouse passes away, if you want to go back and maybe name another child or another relative instead, that waiver only applied to that specific beneficiary. You can't go back now and name it someone else and say this waiver was a blanket waiver to put whoever I want on this form unless it states that. So something to consider. Another example in California, there was a case in his state of Miramontes, Nigeria. I probably butchered that, but in that circumstance, the husband had a bunch of community property. He transferred into 9 different bank accounts without his wife's consent, and he put a payable on death to other individuals that were not his wife. Don't know who those people were, the extent, but the wife didn't know about it. So he passed away. His wife received her community property and more underneath his estate plan, but she also then petitioned the court saying and asking them to set aside the transfers in those 9 other bank accounts because he didn't get her consent, and the court sided with her. So if you are in a state that could have spousal rights, ensure you understand what they are and this is very common. So for in California, I have a lot of blended families that they may say, different children from different marriages, relationships, and the idea is, well, I want to give everything to my spouse, but I want to make sure that my kids are taken care of if my new spouse changes or remarries. And so a lot of people have the idea of, great, well, then I'll just name my kids on my retirement accounts, or I'll just name them on this life insurance policy. Ensure that you're getting the consent of your spouse and anything else you need under your state law to ensure that the plan works out the way that you intended. And have one more mistake with naming beneficiary designations on forms. And a lot of times people say, I don't want to go through the hassle of creating a trust because you have to fund property, which means retitling property and putting it all in the trust. And so they say, I'm just going to name individuals on all my beneficiary forms, and then only the house will go through probate. Or in California, there's a transfer on death deed, which is similar to a beneficiary designation form in some ways. I do not think very fondly of them for various reasons. There's too many ways that they can fail. But someone may say, I'm going to put the house on a transfer on death deed, name beneficiaries on all of my accounts. I'm set. There's nothing left. I don't need a trust. But let's say that trust transfer deed doesn't work. Maybe you forgot to file it within 60 days of signing it, or California revokes the law, or you name someone, and similar to other beneficiary designation forms, that person is now deceased. Well, that property is going to end up in probate, which is the process we talked about you want to avoid, generally in California at all cost. And the problem with that is during that time period of the 15 months, 2 years, however long it takes, the executor or the agent that you've named under your will has to still pay for the mortgage payments and the insurance and the probate fees, and they're having to pay all these costs, but you have named direct beneficiaries on all of your other accounts. So this person has no money to pay these expenses and throughout this entire process. And so this can create a lot of frustration, turmoil, and discord amongst other family members, because the person, may say, well, we need to sell this house or we need to transfer it. Can each of you give me $5,000 back from your designation forms to help me pay for these costs in the interim? And nobody's legally required to do that if they're named as a designated beneficiary. So keep in mind, if you have any assets that could result in probate, you want some liquidity somewhere to be able to pay for these expenses, your burial, other costs that may come up. And that is the end of the presentation, right at about 30 minutes. But if anyone has any questions, if you want to put in the chat, let us know.
Yeah, Aaron. Yeah, we got a few questions throughout the way here. So the first one, I want to start and go back to the beneficiary designation form. So you said, let's say, for example, so the beneficiary designation form supersedes the will and the trust, right? So if a husband and spouse were to have created a trust, they get divorced, one of the spouses, they now get remarried, and on a beneficiary designation form designates their new spouse as the primary beneficiary to that account, let's say, that would overcome the trust that would, let's say, if it was never updated, that was originally there.
All right, so at least in California, and I think I understand the question. So beneficiary designation forms and who you provide your property to on those documents, whatever that document says overrides anything that you may state in your trust or your will. So if you put an ex-spouse on a beneficiary designation form because you were married at the time, you're now divorced, and in your divorce decree, it doesn't specifically state that they no longer eligible to receive anything, or maybe they don't realize you, whatever the circumstance may be. If you then create a trust with your new spouse and you name your new spouse and your children, and you say that you want everything that you own to go to your new spouse, well, it's not going to include this life insurance or retirement account unless you update it to put the spouse and the children as beneficiaries on there. So again, life-changing events, new kids, death of family members, new marriages, really ensure that you go back. And part of the process that I go through with my clients in the very front end is a questionnaire where they're listing every asset they own, all the substantial property that they own. Also, too, bank accounts, retirement accounts, brokerage accounts, life insurance. And as part of that process, I require them look to see who the beneficiary is. And very frequently, it's not who they thought, or they didn't name someone, or a lot of times too, they forget even, because they've had so many jobs, different employers, who has what retirement accounts and pension accounts. And it's really useful to go through at least once the practice of documenting all of that, because it's very frustrating for your loved ones if they need to either come in as trustee to manage your trust, or something were to happen, all you have is a will, and they have no idea what you owned, what institutions have it, how many accounts, bank accounts, money. But if you provide a spreadsheet, Excel sheet, however you want to set it up, to at least give someone else guidance as to what you own and where it's at, it'll make their life a lot easier. Otherwise, they're going through your mail, they're calling out employers. It can be a nasty process.
Yeah, I've seen that firsthand, unfortunately. So so kind of, you mentioned a bunch of like life insurance, retirement accounts, taxable accounts, all these different things. Should the same beneficiary be listed across all of them, or is it kind of more personal preference as far as how you want to designate primary and then contingent beneficiaries?
So it's all up to you, keeping in mind, again, the spousal rights. So if you are married in a state that has spousal rights, take that in consideration. They may need to be named on certain kinds. But for instance, say you are a single woman, never married, you have 2 children, you could decide, I'm going to leave this retirement account to this child and this other one to this child, and then reverse name the other child as the backup. That may be your form of estate planning, assuming that each child is going to receive whatever's left underneath those retirement accounts. So keeping that in mind, I would also keep in mind, if you are considering, say you have a whole life insurance policy and you also have a retirement account, and you say, all right, well, I'm going to name this child for retirement and then this one for life insurance. Keep in mind and think ahead as to which accounts you may deplete throughout your life. For instance, we're living a lot longer than we expected. Women particularly, were prone to dementia and other health issues, but can still live a very long time. So because you're required at a certain age to start taking distributions from retirement accounts, let's say you did that, child 1 got a retirement account, number 2 got a whole life insurance policy, you could deplete some of the retirement money or all of it throughout your lifetime. And then what you intended as an estate planning mechanism could result in one child receiving significantly more than the other.
Excellent. Yeah. Getting a lot of good questions in here. So one that we should have maybe asked you in the beginning too is, the beneficiary designation form. Where do we get that? Is that something that someone like me, a financial advisor, would include in my maybe new account paperwork or documents that's assigned initially? Is that something that you'd mentioned might be available on California's state website? Is it something you provide?
So the beneficiary designation forms are usually owned and coordinated by the institution where that account is going to be held. So if it's a Fidelity retirement account, you can actually go online, log into your portal, and a lot of them make it very easy for you online to just navigate within your account, and you can update your beneficiary designation forms online. Other ones, you can go to a branch, ask the institution for a copy of that document and make sure that it's updated as well. But this is a document that is owned, for lack of a better word, by each institution that's managing whatever property that is. So if it's, your employer, you're registering for life insurance, you're doing it online as part of HR, somewhere in that process is going to have you name a beneficiary designation throughout it.
Great. So as we learned, the idea is to avoid probate at all costs. If you have property in California, if you have property that essentially is handled by a beneficiary form, so it's designated there, do you need a will or trust? Does that still benefit you upon your death?
So it's really going to come down to the individual specific circumstances. So each state's a little different. Some states like California, it's really beneficial to have a trust. But then also too, if you were to pass away and you had nothing, no will, no trust, no documentation at all, then the state has kind of default rules that will apply, and they look to the nearest relatives that would receive, and it's a whole process. Some states are not as strict, and it's not as much of a painful process as California makes it. So it's really going to depend on your state. I will say though, as part of, and this is kind of outside the topic of beneficiary designation forms, but as part of what I provide to my clients, it's not only a trust and a will, but also the financial power of attorneys. But there's also too a lot of power of attorneys that can be provided relating to medical matters, which is something else you should consider as well. If you're not in a position to be able to make decisions about your own health, to go ahead and have something in place to make things easier for your family that's designating who will make those decisions for you, and kind of your general wishes. So I generally recommend some form of estate planning documents be set up for every individual.
And so this might tie into this next question then. Because homes they're titled, if it's a married couple who owns it, it's titled in their names. And if there are adult children in that family, should they be included? We talked about TOD, right? The transfer of death. Should they be included in that sense, or should that home be put in a trust with the beneficiaries title or labeled as the adult children?
So again, unfortunately, and this is the legal speaking, but it'll probably depend
Mhm.
more on your specific circumstances. So again, in California, we have transfer on death deeds. They're still relatively new. I think there's a lot of administrative components that can trip people up and could result in property not transferring as they want. So I would be cautious about doing that. Other states, ladybird deeds, they may have been around longer or may be a good option. Also too, really keeping in mind, and I would recommend you speak to someone wherever you're located. So like for instance, in California, Proposition 19 passed February of last year, and that had significant impact on transferring property from parents to child, and certain exceptions that in a lot of cases will result in reassessment of property. And so that's a little bit more of an involved question that probably depends on your exact circumstances and where you're living.
And I suppose your response probably would be pretty similar whether someone owned the home outright or if there was a lien against it or a mortgage.
So for instance, in trust, I typically will include language if, a family says, I want to pass the family residence to our children. I will generally include language on there, whether if there's still a mortgage on there, it'll be subject to that mortgage, which means the children will have to refinance or get on the loan in order to continue to make payments. Or if the parents want other liquid assets, say in bank accounts or elsewhere, to actually pay off the remainder of the mortgage so the kids get it outright. It really comes down to contractually how you want to set that up.
Gotcha. So another question here that came in, actually, there's been a few questions kind of around the spousal rights that we had talked about. Does it apply to non-married partners who are living together? And maybe you could kind of explain there's some differences in, where that specifically applies versus maybe where it might seem on the outside like it might apply, but actually doesn't.
So, and in California and the federal government, there is a definition of marriage and spouse. We have each state has different designations. So there's different options. Again, this is really going to depend on where you live and how that state's defining spouse and who's included and who's not. California is not a common law marriage state, so common law rules do not apply, which is where people are living together for long periods of time, but aren't necessarily ever married. Other states will actually apply at a certain point a common law marriage and can actually provide certain rights to the individuals for that. So it's going to depend a little bit on your state, if they have domestic partners, if they have common law marriage, and what the requirements are for that. But I'd definitely look into it. And most institutions, hopefully, if there is any spousal rights, would be providing some kind of waiver or a form to that point, but that's a good question that you should ask.
Gotcha. And then because we have used the terms kind of together here, you talk about a will and a trust. Just briefly, could you explain kind of the difference between those two?
So in California, at least, two very different documents. Wills is what most people think about estate planning documents. Some of the differences in California, at least, and why I favor trust over wills in most circumstances is in California, at least, wills are public knowledge. In the sense of when someone passes away, your executor, your agent actually lodges a copy of the will with the court and it becomes public knowledge. So there's actually some celebrities you can look up that did no estate planning or they only had wills, and you can go and actually pull a copy of their will and who they left what to and how they went about it. So that's one major difference, as well as wills, I don't think provide as much flexibility. They go into effect upon the passing of that person. And when most people think about estate planning, that's really what they're considering is when I, pass away, who do I want to get what and when? But what a lot of individuals aren't considering is, again, the circumstance, for instance, if I were to develop dementia later on in life, I'm technically not deceased. So my will does not apply yet. Whereas in my trust, I can outline in those circumstances of capacity. How is that determined? Is it determined by two physicians? Is it determined by my spouse and an attending physician? And if that circumstance arises, it actually allows the trustee to step in and manage your assets for you. So in that circumstance, if I had a trust, my trustee could be paying my medical bills, paying my nursing home care cost, anything that happened for me while I'm still alive. Whereas with a will, those assets are not distributed until you're passing. So you'd have to rely on other kinds of documents like power of attorneys if you don't have a trust or something else in place. So those are two differences, as well as in California, any property that's in a trust is a non-probate asset. So what that means is that in the goal of most clients, I say, no point in creating a trust if you're not going to put any of the assets in the trust name or fund it. So if you put your house, you put your checking and savings account, your brokerage account, all in your trust, when you pass away, those assets and those property aren't included for determining whether a probate process has to be opened. Whereas if you don't have a trust, or if you have a trust and you fail to put any of your property in it, it could trigger that probate process, which is what happens if you only have a will. So hopefully that answered the question.
Yeah, no, thank you, Erin. So it sounds like in summary here, fill out a beneficiary designation form and make sure it's current in California.
Yes.
Yeah. So I think we had a lot of really good questions, and Erin, yet again, you just astound me with your breadth of knowledge, and I'm so fortunate to work with you. Thank you so much for being a part of this. Marche, thank you. I'll just pass it back to you.
All right. Well, thank you so much, Erin and Chase. What an informative discussion. I will ask our participants if they have more questions, go ahead and leave them in the chat. As I close, leave your phone number. I'll go ahead and capture that, and we can get those answered if you have any more questions. Once again, thank you, Chase and Erin. Thanks to the organizations who have made this possible. And let me go ahead and pull up this next slide here. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for you, your situation, and your financial questions. Our matching service is free to you, and every one of our advisor partners is committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. We're getting some thank yous from the chat. Thank you very much for being here, everyone. And we look forward to seeing you at another webinar soon.